So part 3 of our real estate contract series is we're looking at closing documents, payments, delays, and signing off on the agreement to finish it up. Here we go. So we've already talked about RPR, real property reports, and title insurance, which is reflected in 10.2 of the agreement. This is a common one that's changed or struck out in favor of title insurance. And some of our other videos kind of cover the positives and negatives of both of those. But in short summary, a real property report provides a compliance certificate from the municipality, which guarantees that all the structures that are built on that property are compliant with their building regulations. So you know that nothing's wrong. Title insurance is in case there is a problem down the road, you can use the title insurance to have to pay for that cost. RPR is better and reduces more risk. It costs more and takes more time to get. So payment and costs. The buyer will pay the purchase price to the lawyer via trust check or bank draft. So what we're talking about is certified funds. A lot of times it comes via wire transfer as well. Especially if they're not in the same community. And then again, items such as real estate, property taxes, local improvement fees, utilities, rents, all those items are just offset. So for example, if it's a condominium fee, that condominium fee gets split per month. And so it's going to be how many days in the month. So if it's, for example, the month of June, there's 30 days in June. And if it's going to close on the 16th of June, then the one party who is selling is responsible for the first 16 days of June for the condominium associations for June, and the second party who's buying is responsible for the latter 14 days. So those would be adjustments that you see on sales all the time. Same thing for property taxes, depending on how many days are in the year and how they're paid, or if they're on the TIPS program or not. When you look at the discharging of items on a property as well, sometimes there are items that need to be discharged, like mortgages. And so those things get discharged based off of the seller's obligations as well. But sometimes there's liens or other things like that. And so the parties will, in sorting them out, here's the obligation that the purchase price will be used to pay off, any liens that are on the property or pay off the mortgage prior to it going to the seller themselves. Same thing, requirement to pay out the realtors built into the realtors contracts. So that shouldn't surprise anybody. And again, the buyer is the one who's paying the cost to prepare, register, and discharge the buyer's caveat based on the contract in registering the transfer of land. It also covers if there's any delays on closing. And so typically when you're talking about delays on closing, there's things like the bank is taking longer to transfer their financing obligations. And so what it basically covers is you have to pay interest rate on the mortgage. And so it's a way of kind of putting in what is the actual cost of doing this. A lot of times too, lawyers will prepare under the Western Law Society's conveyancing protocol documents such as transfer back documents. And those documents help facilitate the process. So if there is a delay, they can stay on, the purchaser can stay on as a tenant at will, which means that they haven't taken possession of the property. There's no transfer of ownership, but they can have a period of anywhere from 7 days to 2 weeks to just kind of overcome whatever that obstacle was. Bank made a mistake, sent the wrong bank account. So I've had that happen before. Bank took a deduction off of the mortgage that wasn't listed in their documents. That happened before. So there's other examples where, again, there's been bank errors, and they happen occasionally. People are people and they make mistakes. So this just allows a day or two to adjust for that. So insurance, this is really important. I've had some people, thankfully, not make this mistake, but they cancel their insurance the day of. And if you're closing at noon on that closing date, you're liable for any damage to that property up until noon. So you know what? Cancel it the next day. Have that 1 day overlap that avoids any confusion. And if there just happens to be an issue, you're not fighting over who's responsible for the fire that happened on around noon at the point of closing, because hopefully you both have insurance that's effective that date. And there's remedies that cover things like, if you are the seller, the ability to ask for costs and damages associated with the purchaser's inability to complete the agreement. If you're the buyer, the ability to ask for your deposit back, to file a lien against the property, or seek something called specific performance. Specific performance basically says that this property is unique and that there's no other properties like this. And as a result, you as the buyer can buy this particular property, and money in and of itself is not a sufficient remedy. And any notices under this contract, such as amendments or things like that, have to be in writing and based off the contact and contract terms below, that we have to, and that the document, regardless of whether it's submitted electronically or signed electronically, is all just treated as one original document. And that's why most of these real estate contracts are signed via DocuSign or signed via Adobe Cloud type sign, Adobe Sign. And if these provisions weren't included, well, then they couldn't be, and they'd have to be done in person. And that's how they did it many, many years ago. Obviously, it makes it much more harder for people traveling from different places, and this enables them to have a local realtor where they may live further away, and they won't have to sign it in person. So again, who the buyer's brokerage, who the seller's brokerage is, who their specific names of the representatives are. They don't have a brokerage itself, then who's actually authorizing the transfers and who's actually authorizing them to enter into the agreement, that these are their final contract terms, that there's no collateral or side agreements that aren't made in writing. If they were, they'd be attached to this as an amendment. And again, legal obligations begin when it's accepted. And again, transfers to everyone else. So once you sign it, for example, if say the seller passes away in between after the closing conditions have been removed, but before the closing date itself, then they're still obligated to continue with the contract. So that's happened a couple of times before too. Now, when we talk about the offer itself, so you have an offer and acceptance are your two prime factors when creating a contract. As soon as someone puts in a counter offer, adjusts the price, adds a new condition, then that actually terminates the original offer, allowing the seller to not sell it to the purchaser again. So that's always the risk, especially when you're looking at a contract for a property where there's multiple buyers that are interested in it. So bear in mind that whatever you're putting down here, if you decide to change the offer, or if the buyer sends you a counter offer back on price, you can either accept it or reject it. And if you say, hey, what about this price? They can simply say no and move on. And then that's why their rejection part is in there, right? There's no counter offer being made. And then conveyancing instructions. So this tends to be the name of the lawyers who are going to get the instructions, because then the real estate will pass on this agreement, as well as what they can pass on to the mortgage company to pass on the mortgage instructions, that sort of stuff as well.